Hello again. This is the third installment of my brand new series. I don't know everything, but I do know some things. Today's presentation is on basic criminal law, and I'd like to note that when I say basic, I mean very basic. When it comes to law, I could spend 25 years going over everything and another 25 years going over everything that's changed in the last 5 minutes. For example, here's a Missouri-specific law that you've probably never heard of before. A person needs a permit to shave while driving. Now, where do you get one of those permits? I have no idea. Maybe like Walmart with the fishing and hunting permits? So let's start with the definition of a law. A law is a rule of conduct with binding legal force and effect, which is recognized by a government controlling authority, and its purpose is to maintain order in society. Now, because of this, if a law is broken, there will more than likely be consequences. Now, there are four sources of American law: U.S. constitutional law, U.S. federal law, state constitutional law, and state laws. Here's some more on the four sources of American law. The U.S. constitutional law is the supreme law of the land. This means that if there's a conflict between the U.S. constitutional law and any other source of law, the definition of the U.S. constitutional law will reign supreme. Both U.S. constitutional law and federal law overrule both state constitutional law and state law. The state constitutional law is a subset of the U.S. constitutional law, and it includes state-specific areas of the law that the U.S. Constitution does not cover. And finally, state and local laws take precedence only when all other areas of law do not cover the subject matter. Okay, so there are two types of law. Procedural law, which is the process that the courts use to decide cases, and substantive law, which is subject matter law. Procedural law is going to be the type of law we are bound by, and there are three subcategories of it: criminal, civil, and administrative. Substantive law is the area of law that an attorney may specialize in, like contract law, tort law, or elder law. Okay, so we're going to focus more on procedural law since that would be the kind of law that most of us have to deal with. And there are three subsets of procedural law. First, there's criminal law. Criminal law relates to conduct perceived to be threatening, harmful, or dangerous in any way to property or person. Just some examples of criminal offenses include murder, assault, theft, or drunk driving. If you are found guilty of a criminal offense, the consequences can include jail time or even prison time. If I could give you any piece of advice for living your life, I would highly suggest to try to refrain from breaking any criminal laws. I interned at a county jail while I was in college, and it does not seem like it would be super good time fun. Now on civil law. Civil lawsuits are filed by a private property and are typically a dispute between private citizens. And since these suits are between individuals, they're not associated with jail or prison time. And finally, the third subset of procedural law is administrative law, which is also called regulatory law, and are typically federal agencies that are established under the executive branch of government. Examples include the FCC, FDA, and the CIA. These agencies define rules and make decisions that minimize confusion in the law process. Okay, time for a fun fact. Well, unless you're the defendant. You can have both criminal and civil charges filed in the same case, but the charges must be filed separately. Today, we're going to be focusing mainly on criminal law. So let's take a look at a term concerning criminal law that you may have heard before: due process. Due process states that the court must consider every legal right to which a person is entitled. In general, these rights state that everyone is guaranteed a fair trial regardless of who they may be. So what is a crime? Basically, if a law is broken, that constitutes a crime. Now, there are 4 categories of crime: a felony, a misdemeanor, an inchoate offense, and a strict liability offense. Let's start with a felony. A felony is a crime that typically involves violence in some form and is usually punishable by imprisonment, and in some more serious cases, death, which is also called capital punishment. Examples of a felony would include murder, burglary, sale of illegal drugs, or rape. Next, we have a misdemeanor. This type of crime is less serious than a felony and can be punishable by less than 12 months in jail. You can also receive community service or probation. Probation may not seem like a big deal, but remember, if you're charged with a misdemeanor, get placed on probation, and break the law during your probation, that can still mean jail time for you. Probation is not a get-out-of-jail-free card. Now, misdemeanor offenses include drunk driving, shoplifting, minor or simple assault or battery, trespassing, or vandalism. Third, we have an inchoate offense. Inchoate means unfinished, and an inchoate offense is one that is not complete. This type of offense can be one that aids in a crime. Examples include an attempt of a crime, conspiracy to commit a crime, or solicitation. Finally, we have strict liability, also known in Latin as mens rea, which means guilty mind. A defendant can be convicted if they've participated without knowledge in a strict liability. Examples of a strict liability crime include statutory rape, selling alcohol to minors, and most traffic offenses. Now, there are different levels of participation in a crime that come with different consequences. Because of this, there are 4 basic levels of involvement in a crime. The first is principal in the first degree. Now, this is a person that actively commits a crime with their own hands. Second is, for obvious reasons, principal in the second degree. A person that is present during the crime and knowingly assists in a crime but does not actively participate would be a principal in the second degree. Third, accessory before or after the fact, which is also known as an accomplice. You don't have to be present during the crime, but you do take action that assists in the crime. And finally, conspirator or co-conspirator. These would be a person or people that plan a crime. Even if the crime is not successfully carried out, they can still be charged, convicted, and sentenced. As I stated at the beginning, there can be consequences if a law is broken. Now, keep in mind that when it comes to law, it's a very gray area and a lot of consequences have dependencies. This means that there are a lot of if this, then that's. In fact, the amount of gray area in law fills so many books that there is an entire law library dedicated to the practice of law. Now, the consequences I'm going to go over are just a generalization to give you an idea of what can happen, but not necessarily what will happen. For example, if you're convicted of a felony, you could receive a minimum of 1 year of prison depending on the class of felony. If you're convicted of a misdemeanor, you could be sentenced to fines and up to a year in jail depending on the class of misdemeanor. Now, since inchoate crimes are felonies that are 1 degree less than a fully completed crime, they can still be punishable by prison. And if you break a strict liability law, they can be civil or criminal, and because of this, the punishment will be impacted by the charge. Now, that's all I have for you today. I'd like to thank you for joining me. If you have any questions, would like me to elaborate more on criminal law or would like me to present on any other kind of law, please drop a comment below. Thanks. Bye.